I will review each charge and inform you of the information underlying the charge, and I will then ask you to admit or deny each charge, and I'll give you an opportunity to respond to the charge. If you choose to make no reply to the charge, the hearing will proceed, and my recommendation will be made on the basis of the information available.
In district court, some of the charges were dismissed, but when he was indicted, I believe he's got a copy of the indictment.
They were re-indicted? Okay. All right. Yeah, Mr. Davies, what I understand from Ms. Baxa is originally, when his case was heard, there was a preliminary dismissal of some of the counts, but when the case was indicted, the charges were reintroduced. So we're still looking at the same ones. Okay. Mr. Davies, does your client admit or deny those charges?
Mr. Bobo denies the charges.
Okay. Is there anything he wants to say about them?
Mr. Bobo is asserting his Fifth Amendment right at this time, given the pendency of the case in Prince George's County.
Okay. Felon in possession of a firearm. The preliminary, at the first hearing that we had back in May, you denied those charges. Do you still deny those charges?
Yes.
Okay.
Yeah, Mr. Bobo. Is it the appropriate time for my request?
Please.
Yes. On behalf of Mr. Bobo, at this time we would request that the final outcome of this hearing be postponed until he may resolve the criminal case in the state of Maryland, maybe by way of writ. We understand there are civilian witnesses here today whose testimony should be taken because they are present. However, Mr. Bobo desires to testify in the present hearing, but upon advice of counsel, he's unable to do so until he resolves the criminal case in the state of Maryland. And also, I think the outcome of the criminal case would assist the Commission in determining the appropriate outcome of the present hearing.
All right. I'm going to take that under advisement right now, Mr. Davies, and I'm only going to comment on this. I have not made a finding on any of the charges yet, and I want to make sure you understand that, Mr. Bobo. Just so you know, Mr. Davies, I'm sure you know this, but bear with me while I remind you, even if there's a even if the charges are dismissed in PG County or there's a finding of not guilty, the burden of proof is substantially different in a parole proceeding. So while it will be certainly relevant what happens in any ancillary criminal charge, it doesn't control the parole commission. I'm just saying that just so you know that for your information.
So it's my understanding that right now there's a warrant for Mr. Bobo in Prince George's County, and they are waiting for his release in the district.
Okay, gotcha. Is that your understanding, Ms. Baxa?
Yes, sir.
Okay.
Excuse me, yes.
Whatever. Sure. Okay. All right, so all of those are still pending.
Yeah, so Mr. Bobo's, we can proceed under the way we were going to proceed, but he's not giving up his right to confrontation of the other witnesses that are listed.
Understood. Understood.
Just for the record, I want to make it clear that by proceeding under that arrangement, Mr. Bobo is in no way giving up his right to confrontation of any other witnesses.
Can you tell me what the legal status is of these charges, please?
At this time, Mr. Bobo was out on a bond pending the trial in Prince George's County Circuit Court. He was picked up on the warrant from the United States Parole Commission.
So you haven't had a trial?
Exactly. And unfortunately,
Okay.
Mr. Bobo was unable to attend court in Prince George's County because he was held in the District of Columbia.
We haven't had any convictions, nor have we had any acquittals or dismissals.
That's correct.
Is that correct? This is an administrative hearing, and the rules limiting the type of evidence admissible in a criminal trial do not apply. What I'm going to do now is call the police officer in, and I'm going to ask for the police officer to provide her testimony. Now, Mr. Bobo, here's what's going to happen. I'm going to bring the police officer in. I'm going to ask Ms. Baxa to move to the other side of the table so I can have the police officer sitting next to the tape recorder. And then I'm going to ask the police officer what she knows, where she saw you before, what information she knows about the case, anything that's important to the Parole Commission about you and these facts that have been presented here, these allegations. Then, when I'm done, Mr. Davies is going to be able to cross-examine her to ask any questions on your behalf. I may have some follow-up questions for her, and then Mr. Davies may have some follow-up questions. After we've both gone back and forth and we've asked all the questions that we want to, then I'm going to dismiss that police officer. Now, we don't have the victims here today to testify. So it is unlikely that I will be able to issue a recommendation to the Parole Commission because you've got the right, you have to have the opportunity to confront the people who are making allegations against you. So what I am going to do today, though, is preserve the testimony of Officer Smith certainly find out what she's got to say. And I'm going to ask Ms. Baxa if she knows anything about the case, if she's talked about the case with you, or if she knows anything that the Parole Commission should know about the case in her opinion. That way, when we come back, we won't have to have you come back again, since there aren't any administrative charges. Okay, does everybody understand?
Yes, I do have one question. Procedurally, as the attorney for Mr. Bobo, if I have an objection to part of the officer's testimony, do I make that now, or do we wait till we...
Oh, go ahead and make it now.
Well, I'm not sure what the officer's going to say, but I'm going to object to her repeating any hearsay against Mr. Bobo.
Oh, hearsay isn't excluded in an administrative hearing.
Right.
So hearsay can be admitted.
Understood. Specifically, I'm going to object to anything the officer did not see herself as something of her testimony. And the basis of my objection is, I'm going to object, and I don't know if you were proceeding under this line of questioning or not. Maybe I'm bringing this up too early. But I'm going to object if she is able to say anything that the victims in the case said.
I'm going to overrule that objection.
And just for the record, I'm proceeding under the case law of Ash v. Riley that came out on May 5th,
Understood.
2006.
Understood. All right then, if you would be so kind as to move to the other side of the table, Ms. Baxa, I'll bring in Officer Smith. Okay, does everybody understand?
Yes, I do have one question. Procedurally, as the attorney for Mr. Bobo, if I have an objection to part of the officer's testimony, do I make that now, or do we wait till we...
Oh, go ahead and make it now.
Well, I'm not sure what the officer's going to say, but I'm going to object to her repeating any hearsay against Mr. Bobo.
Oh, hearsay isn't excluded in an administrative hearing.
Right.
So hearsay can be admitted.
Understood. Specifically, I'm going to object to anything the officer did not see herself as something of her testimony. And the basis of my objection is, I'm going to object, and I don't know if you were proceeding under this line of questioning